everyone, and welcome to another in the University of Lincoln's Climate Change series. It's great to have you listening and watching today. I'm really pleased to be able to introduce Professor Elizabeth Kirk to talk to you today. Professor Elizabeth Kirk is Global Chair of Global Governance and Ecological Justice and Director of the Lincoln Centre for Ecological Justice. She sits on the University of Lincoln Sustainability Research Theme. Elizabeth was formerly a research professor of international environmental law and co-director of the Centre for Marine Ecological Resilience and Geological Resources, and a member of the Sustainable Futures Interdisciplinary Steering Committee at Nottingham Trent University, and has also previously worked at the Universities of Dundee, British Columbia, and as a solicitor in Scotland. Elizabeth's research addresses the production of normativity in international environmental law. What causes actors to comply with the law? Her work has clarified the role played by scientific understanding, legal form, culture, and individual actors and groups of actors in creating laws that encourage and enable states, companies, and individuals to comply with them. Elizabeth's research is currently addressing complex, multifaceted problems such as plastics pollution and energy efficiency. And when she's not working, she enjoys being outdoors, cycling, running, skiing, and gardening. So, big welcome to you, Elizabeth, and we're all looking forward to your talk. And as usual for our audience, we'll have an opportunity for questions at the end. So please do post your comments and questions in the chat alongside while Elizabeth's talking, and then we'll pick them up at the end of her talk. Okay, over to you.
Great. Thank you very much. Thank you for a very warm welcome, Libby, and thank you all for joining us today. And thank you also to Tammy, who has helped with the organisation of this event, and to any others involved in the organisation of the event. So I'd like to talk to you today about the challenges of climate change law. When I talk about challenges, I'm talking about challenges with the law as it currently is and as it has developed over the last about 30 years. And I'm talking also about the challenges of how we might implement it better or improve it, and of how we might enforce it as well, whether it's possible to enforce it. So I'm conscious that this lecture is being attended by people from a diverse array of backgrounds, so I'm assuming that you may know something about the law, but may not know as a lot about the details. So I'm going to talk a little bit about some of the details, but try not to get too far into legal and technical jargon. But just before we move into the talk itself, just an explanation of the photograph in this image. It shows the peak at the top with some white, and it shows you Mont Blanc, and it's just, I guess, a reminder of the fact that climate change sometimes doesn't have the most obvious impacts. You know, we may not notice them immediately, but over time we certainly are seeing issues like the ice caps disappearing and slowly reducing. So that is one of the challenges with addressing climate change through law, in that sometimes it's difficult for law to address something that's not immediately obvious, if it's not an obvious immediate threat. But let's have a look at some of the law. You may be familiar with the Climate Change Convention, but there's a few things I'd like to say about it which help explain why it's been so challenging to get states to take measures that are really effective to mitigate climate change and their emissions of greenhouse gases. The first thing is, in the title of the convention, it's referred to as the UN Framework Convention on Climate Change. And the word framework is there deliberately because the idea behind this convention was that it would set out the basic obligations that states would comply with, and then subsequent agreements would be entered into which would provide more detail. And that approach to lawmaking, it's called a regime building approach, it's quite well recognized in international law. It's been used in a number of instruments, Perhaps the one that you might be familiar with is the Vienna Convention on Protection of the Ozone Layer, where you have that convention followed by the Montreal Protocol. And the more detailed obligations are found within the protocol rather than in the convention itself. So the same thing happened with the Climate Change Convention. And you have in Article 4, I guess the primary obligation that's placed on states, which is addressed to Annex 1 countries. Those are the industrialized countries who are asked to commit to adopting laws and measures to limit their emissions of greenhouse gases and protecting and enhancing their greenhouse gas sinks and reservoirs. So it's a general obligation. There's no specification of the time frame. There's no specification of the degree to which emissions are to be limited. That was intentional. It was expected that a subsequent agreement would emerge, and as I think we know, that subsequent agreement did emerge, the Kyoto Protocol. And the Kyoto Protocol then did contain more detailed obligations. So it again called on the Annex 1 countries, again primarily the industrialized states, to reduce their overall emissions of gases by at least 5% below 1990 levels within the period of 2008 to 2012. So there was a clearer obligation, a clearer standard to meet. There was a clear timescale in which to meet it. But again, if you look at the Kyoto Protocol, you'll see that there's no real specification of precisely what measures states should take. That was left to the individual states to decide for themselves. And again, I think I probably don't really need to say too much about this to remind you of it, but as you can see, the time period that was given in the 1997 Kyoto Protocol was that emissions were to be reduced within the period of 2008 to 2012, and the idea was a subsequent agreement would be adopted. The initial idea was a subsequent agreement would be adopted, or a revision of the Kyoto Protocol would be adopted, which would allow, again, a ramping up of the obligations on primarily the industrialized states. Now, the less industrialized states, or those that were rapidly industrializing, while they didn't have specific obligations under the Climate Change Convention or under the Kyoto Protocol, were within both documents called upon to take steps, to take voluntary measures to limit their emissions. But it was voluntary and there were no specific targets as such. Now, again, as I guess most people will be aware, one of the problems with the Kyoto Protocol was that a number of states either decided not to sign up to it and not to commit to the obligations that were stated in it, or withdrew from it. And when it came to the renegotiation, that renegotiation really came to a halt, primarily because some of the industrialized countries argued that it was unfair that they should take responsibility for meeting all of the reduction in greenhouse gases when other states were rapidly industrializing and rapidly increasing their contributions to greenhouse gases. I mean, we can debate the question of fairness or otherwise, and I will come back to that in a moment later in this lecture. But primarily that was the reason that we didn't go forward to a stronger version of Kyoto Protocol. Instead, what we got was the Paris Agreement, adopted in 2015. And under the Paris Agreement, it's left to individual states then to set their nationally determined contribution to the reduction of greenhouse gas emissions. And they are encouraged again to take steps to conserve and enhance as appropriate sinks and reservoirs of greenhouse gases. So, of course, one difference with this, the Paris Agreement, is that it applies to all states. They're the same obligations, if we can call them obligations, apply to all states equally. But as I said, it's a step back from the Kyoto Protocol in that it's left to the individual states to set their targets. So they're not really being held to account in the same way that they might have been held to account under the Kyoto Protocol. There is a further issue with the Climate Change Convention as a whole, and that is that even if under the Paris Agreement, a state like the United Kingdom sets its own nationally determined contributions, we don't really have an independent mechanism to check whether those states are meeting their commitments. So, you know, in the United Kingdom, if an industrial factory gets a permit to produce particular or to emit particular pollutants, the Environment Agency can go in and inspect and make sure that the terms of the permit are being complied with. We might hope that there would be something equivalent in international law, but there isn't, and nor is there an equivalent to a police force. So what happens instead under the Climate Change Convention, the Paris Agreement, is that states are asked to report themselves on the measures that they've taken. And then their reports are reviewed by the other states. So we might think, well, why do we have these sort of fairly vague treaties with these weak obligations in them? And I suppose the primary reason is the central concept of sovereignty in international law. Sovereignty is a topic that we've heard a lot about over the last few years in Britain, but it is really key in international law. It's a concept that's found under customary international law, which is not written anywhere, but rather created through the practice and beliefs of states that they are obliged to practice and behave in a particular way. And the idea of sovereignty was stated quite clearly in this arbitral tribunal, the Island of Palmas case between the Netherlands and the USA. That was a dispute about which of these two countries owned the Island of Palmas. But the point for our purposes is that the arbitral tribunal noted that sovereignty between states signifies independence, and that means that they have the right to exercise within their own territory and to the exclusion of any other state the functions of a state. So they can't be obliged to do anything without their consent, and that includes lawmaking. So again, under international law, we don't have a supranational legislator in the way that we have Parliament in the UK able to make its own legislation. Sometimes the United Nations is considered to be the equivalent of an international legislature, but it's not. It does provide a forum in which states can come together to debate particular points, but it doesn't have the power to make binding treaties. Sometimes the United Nations or the arms of the United Nations will facilitate lawmaking, but that's not the same as actually drafting a piece of legislation and imposing it then, adopting it and imposing it then on states to comply with. Instead, for laws to be adopted, for treaties to be adopted, states have to give their express consent. So that might be by signing it, by by depositing an instrument of ratification. So that's basically a letter that's deposited with the Secretariat or with a particular body. But the point is that they have to actually physically do something to express their consent to the treaty. And it's only if they do that that they can be bound. And it's that problem, or the issue of sovereignty, the need for consent, that can make it so difficult to gain agreement to more binding climate or stricter and more challenging climate change agreements. Because we're dealing with a trade-off between the interests and the economies of different states. So we might think, well, we know that climate change is starting to give rise to issues. We know that we can see that we've got, for example, increased flooding and increased risk of flooding. So this is an image of a flood warning map from the Flood Warning Information Service, and it shows the potential risk of flooding from rivers and from sea level, or from the sea, in and around Lincolnshire. So what if we know that we've got increasing flooding events happening because of climate change? Well, could we then, if Lincoln or Lincolnshire is flooded, could we then, the United Kingdom, sue another state, for example? Well, there isn't necessarily a short answer to that. I suppose the answer is possibly. So, although I said that sovereignty is a bedrock of international law, there is also a corollary to that, to the concept of sovereignty. And that was quite clearly expressed in the Trail Smelter arbitration. So the idea expressed in the Trail Smelter arbitration is that if one state allows activities within its territory to cause harm to another state, then it can be held responsible for them, because it is in effect interfering with their sovereignty. So in the Trail Smelter arbitration, the facts that arose were that there was an aluminium smelter within the town of Trail in British Columbia, and it was emitting fumes which were then being blown across the border into the United States, into Washington State, and causing harm to the fruit and other crops that were being grown there. There was no dispute between the two countries about whether or not the fumes were causing the harm. It was agreed that that was the case. The question before the arbitral tribunal was simply, is Canada responsible under international law? Does it have to make reparations in some way? And the answer was yes, it does. It is responsible. It has to, a state is responsible for any activities that it permits or allows within its territory that cause harm to another state. And in that case, one of the outcomes was that Canada was asked to raise the height of the smokestack coming out of the aluminium smelter. So that might give grounds for legal action then to be taken to try and stop other states emitting greenhouse gases that lead to flooding in a particular country. And we can go a little bit further than that, because the Trail Smelter arbitration case related to a smelter that Canada was aware of. But the next case, the Corfu Channel case, reminds us that it's not enough for states simply to say, well, we didn't know that this was happening. We didn't know that there was somebody carrying out an activity that was going to cause harm to another state. So in that case, some British minesweepers were damaged from mines that were laid in a shipping channel off the coast of Albania. The shipping channel came within or lay within Albania's territory, and the UK sued Albania for allowing or laying the mines within its territory and thus causing harm to the British ships. Albania argued that it hadn't laid the mines, and there was no evidence to say conclusively that it had. And it also argued that it didn't know who had laid the mines, so it wasn't responsible. But in that case, the International Court of Justice found that Albania had an obligation to be aware of what was happening within its territory, particularly in the Corfu Channel, because that was a busy shipping lane. So in areas that where it might anticipate other states would come into contact with Albanian territory, it was meant to be aware of what was happening there and to take steps to control what was happening within its territory. So it's not enough to say, well, we didn't know an industrial plant, for example, was causing all of these emissions. It's up to the state to take steps to be aware of the harm that might be occurring, and to, in this case, in the Corfu Channel case, to inform other states of any risk to them. So there's a route there, there's a potential legal route to taking a case, but of course it's not quite that simple. The first problem, I actually to go to the point at the bottom of the slide, the first problem is the problem of causation. And while we know that climate change is giving rise to more extreme weather events, our problem in law is that we would have to be able to show that the specific flood that we were wanted to sue for was caused by climate change and not one that would occur naturally. And we have to be able to show that the actions of another state led to that flood. Now, it would be quite straightforward if we were talking about a flood that was caused by a dam on a river course that was shared between two states, if that dam was breached and then you had a surge of water downstream. But when we're talking about something like climate change, it's not so easy to make those connections to say this specific flood has been caused by climate change, and also to determine which state is responsible for the emissions that have led to this particular instance of flooding. So that's the first problem, the problem of causation. And that's a problem that arises with every case in international law. The second problem, again, is a problem of the legal system. If, again, your property was sued by something that, if your property was damaged by flooding, for example, by something that your neighbour had done, you could ask them for compensation, and if they didn't provide compensation, you could go to your solicitor and ask them to take a case on your behalf against your neighbour through the court systems. It's not quite that simple in international law, because once again sovereignty comes into it, and you have to have the consent of all parties to the case to go to court. Now, there are a number of different tribunals and courts that can be used. There's the International Court of Justice, there's the arbitral tribunals that I've been talking about, which can be established through the Permanent Court of Arbitration. There are tribunals attached to particular other particular international agreements. Most of them will have very similar provisions. They'll provide that, and this is an example of it on the overhead, in Article 36 of the Statute of the International Court of Justice. They will provide that cases can be taken if the parties consent and refer the matter, so on the specific point. If there's a provision in a treaty that the parties to the case are also party to, and if that treaty applies in these circumstances, or if they have given at some point, as an example under Article 36, paragraph 2, if it has at some point given their sort of universal consent to any actions being taken against them before that court, or any actions in a specific area, such as in treaty interpretation. If we start with the last point, there are very few states that have given sort of universal jurisdiction to courts to hear any cases that come before them. There are some who have consented to any cases on particular areas coming before the courts, but generally that's not a provision that's relied on so much in international law. It's more likely that you have to have consent to the particular issue, or that consent has come through the parties having signed another treaty. So the question then is, does the Climate Change Convention or the agreements under that, do they provide for cases to be taken to, for example, the International Court of Justice if there's a dispute? And there is a provision under the Climate Change Convention, but what it requires is the states to make a declaration that they accept that disputes under that convention can be heard before the International Court of Justice. So if we wanted to sue for example, flooding, we would have to make sure that we had the consent of those states that we wanted to sue. And as you can imagine, that isn't necessarily going to be easy to get. So I'm just going to skip that slide. So what can we do? Is there something that states could do either unilaterally or collectively to strengthen or improve the law? Well, possibly there are. But what I like to do next is think about what could possibly be done and how practical it is, or how likely it is to succeed, and what might be the challenges in taking unilateral or collective action to strengthen or improve the law. So the first point is that we can see from international law that it's possible to have stronger and clearer regulation. And I've given on this slide some examples of treaties that are perhaps clearer than in the terms of the obligations that they place on states. I mentioned the Vienna Convention earlier, the Vienna Convention for the Protection of the Ozone Layer, and it's a very good example, as I said, of the regime building approach, where you have a general agreement in the Ozone Convention to take measures to try and protect the ozone layer from harm from particular chemicals. The details, then the stricter measures, are then found in the Montreal Protocol, which has been amended over the last 30 or so years when it's been in force. And over that time, more and more chemicals have been added to the list of chemicals that are either banned or strictly controlled in the way they're to be used. There are other examples as well. The Global Programme of Action for the Protection of the Marine Environment from Pollution from Land-Based Activities. This is what we call a soft law agreement. It's not binding on states, but it's perhaps best understood as a mechanism by which the states, again, agree the basic areas that they want to address, and then come together on a regular basis to discuss best practice in tackling pollution from land-based activities, in identifying key problematic areas that are problematic for all states, and to start to think about where they might need to develop global or regional rules. And through those discussions, there have been a development of some or they've sort of prompted the development, I should say, of certain treaties such as the Stockholm Convention on Persistent Organic Pollutants, the Minamata Convention on Mercury, and the Rotterdam Convention on Prior Informed Consent for certain hazardous chemicals and pesticides in international trade. So each of these provides quite detailed provisions around how the issue that they address is to be dealt with. So we know that in theory it's possible to get stronger and clearer regulation. The bigger question is it possible in relation to climate change? Well, the first issue that we need to consider is, well, what would actually make the law better? What would make it stronger or clearer? What would make it maybe fairer as well? What will states agree to? We could, for example, look at having much stricter standards around the emissions, the permitted emissions level by country. So this gives you a graph of the 100 highest polluting states in terms of CO2 emissions. So you can see there's a couple of clear spikes there. So it would be possible to say, well, it'd be quite straightforward to set sort of fairly strict standards, saying it doesn't matter what the historical record is, we're looking at what the emissions are to now, and we're maybe going to cap them for each state at a particular level. Or, we'll say there's a maximum cap that applies across all states equally, and that might be sufficient. The problem, though, is if you start to look at other ways of measuring emissions, so if you look at carbon dioxide emissions per capita, the states that are the highest polluters are quite different. So if I go back to the previous slide, you can see here China is the by far the highest emitter of carbon dioxide, but when you do it by head of population, it's nowhere near the highest polluting state. It's actually other states like New Zealand that are very highly polluting. So there's a question then about how you agree standards, or how we agree standards that are going to be fair and achievable even for all states. Imposing a cap on a highly populous state such as China would be much harder for them to achieve than it would be to impose the same cap on, for example, a state like the United Kingdom. So a uniform cap is perhaps not the way forward. What we could do is perhaps look at more detailed regulation of individual sectors. So we might look at, for example, more detailed regulation of electricity and heat production, or of a follow is agriculture, forestry, and other land uses, or maybe of industries. So we'd like to talk a little bit more about this idea of perhaps having stronger regulation of particular sectors, and perhaps look at some of the challenges in that. And to do that, I'm going to focus on one very narrow area. So if we were wanting, for example, to impose stronger standards on industry, we would have a question of, well, is it all industries or is it particular sectors? So let's pick on one that's quite topical. Now, I think we might know that a lot of plastics are produced from fossil fuels, and their production can lead to, and does lead to, the emissions of greenhouse gases. And in their life cycle, they can then emit those greenhouse gases as they decay. But I'd like to talk about not so much controlling the production of plastics, but maybe take some very, very narrow areas to look at some of the challenges in how we might act collectively or unilaterally to deal with these issues. And I've deliberately taken something really narrow to start with. And so my example is the example of plastic mulching. Now, if you're living in and around Lincolnshire, you might be familiar with the use of plastic mulching on fields. It's used to increase crop yields, it acts as a barrier to pests and to weeds, and it helps improve as I said, the crop yields. The problem with using plastic mulching is that it also increases emissions of nitrous oxide and methane, two greenhouse gases. And so it contributes to our emissions of greenhouse gases. There are alternatives to plastic mulching. So we could have a question about, well, whether should we collectively as states, should we agree that we're going to ban the use of plastic mulching. It seems like quite a narrow issue, so it should be quite straightforward. There are alternatives there, which shouldn't be a particular problem. And we might want to do that because of the greenhouse gas emissions, and also because the use of plastic mulching can impact on the efficacy of soil as a carbon sink, because when the plastic is used, it breaks down the small particles of plastic that are left on the soil, either through it breaking down or through, as it's removed, just through parts being left behind. Those particles can be absorbed within the soil through the processes that would, for example, through earthworms moving the plastics through the soil, or just through the normal processes of tillaging and so on. When they do that, they interfere with, in effect, the take-up of plant matter that would normally be moved through the soils, and they can interfere with the health and functioning of earthworms, and in that way they interfere with the efficacy of soil as a carbon sink. So we might also want to ban plastic mulching because of the impacts that it has on the ability of soil to act as a carbon sink. So what can we do? Could we have collective action? Well, theoretically, yes, we can. It's possible under the Climate Change Convention, under Article 4, under the Paris Agreement, Article 5. It's possible that the states could come together. But in practical terms, are they likely to do that? Well, it takes quite a lot of effort to bring together the approximately 200 states that there are in the world to get them to agree to a particular measure. And they're only likely to do that if they can see a real concrete benefit to doing so. The impact of plastic mulching might be relatively, and is relatively small compared to other emissions and other sources of greenhouse gases and other things that impact on the existence of carbon sinks and reservoirs. On one hand, that should make it quite a good topic to address, because it's relatively straightforward. It shouldn't be too controversial. There are alternatives there. On the other, the social capital that states would have to expend to reach such an agreement would be probably considered to be too great for the effort that would have to go into negotiations would be too great for the benefit. So it's likely that this isn't going to be tackled unless it's tackled within a much larger framework, a much larger agreement, a process such as the one that we see with the Montreal Protocol, where you have continual review of the measures that need to be taken and the types of things that are processes or uses that are agreed to be stopped. So could a state act unilaterally then? If something the UK thought, well, actually plastic mulching is a bit of a problem and we could do something about it and it's quite an easy win, could it act unilaterally? Well, within its own territory, yes, it can act unilaterally. There's nothing to stop it doing that. So it could legislate to say, well, we're not using plastic mulching anymore. We're going to focus on the use of other forms of less harmful mulches. That's fine. But what if the United Kingdom wanted to say, well, we think this is a problem and it's something that other states could address relatively easily. So we're going to ask those other states then to, or we're going to refuse to import goods, let's say strawberries from other countries or that are produced where plastic mulching has been used. Could it do so? Well, that would involve putting in place, in effect, a technical barrier to trade. And technical barriers to trade are covered under the World Trade Organization. And this is where we start to see one of the other challenges with climate change. Anything that we want to do under the climate change regime or in relation to addressing climate change in law, we have to think about not just the specific laws that apply in that topic, but how they interact with other areas. So it's possible under the World Trade Organization agreements, it's possible then to take measures. So under the Sanitary and Phytosanitary Agreement, Article 2, states can adopt measures to restrict imports of goods that either in themselves or in the way they're produced harm human or animal health. And under the General Agreements on Tariff and Trade, Article 20, they can do the same thing. They can take measures and restrict imports of goods if those goods or the way they are produced harm the environment. If they are going to take these measures, they have to then notify other states under the Technical Barriers to Trade Agreement. the problem, again, when we're dealing with something like climate change, and say, taking the example of this narrow example of dealing with plastic mulch, is that any state trying to reduce the import of goods that are produced with plastic mulching would have to be able to make the case, a clear case, that they do cause harm to human health, animal health, or the environment. And that might be quite difficult to do. In fact, I think that would be very difficult to do with something even as narrow as plastic mulching. Because it's quite a long way from the use of plastic mulching in the fields. Again, we've got to go through the chain of causation. Has that plastic mulching in the field, how much has it contributed to climate change? How much has that impacted on the health of humans or other species or on the environment? With such a long chain of causation, without some other technical agreement that identifies in international law, and some international agreement that identifies that plastic mulching is a significant problem, it's unlikely that there would be agreement to the adoption of a technical barrier to trade around this issue. So in other words, the trade laws might stop a state taking unilateral action to limit imports of goods produced with certain in a way that might in some way contribute to climate change. I want to turn to another topic, so keeping with the issue of plastics, but I'm going to just because I'm conscious of the time, I'm going to leap towards the sort of end of life cycle for plastics. And again, one of the issues that we've heard about so much in recent years is the fact that plastics escape into the environment. I mean, I think we're all aware of it if we look round about in our environment now, particularly over the last year. As litter picking has reduced, or formal litter picking has reduced, you can see so much more plastic found in our fields, on the sides of streets and on the sides of roads, for example. But a lot of the plastics is making its way into the oceans, whether it's being dumped into the oceans or more likely making its way there through getting into water courses and flowing into the ocean in that way, or through being caught in the wind and blown into the ocean in that way. And the issue that I want to talk about today is how that impacts on the ocean carbon sink, and then what laws we have that might help us in addressing that. So I'll try and keep it sort of fairly brief. The key point is that we need to have large marine animals functioning within the ecosystem to help mix nutrients, but plastics get in the way of that, whether that's by trapping them in plastic fishing nets or in those little plastic rings that hold cans together, or whether it's through plastics entering the marine environment and either breaking down into microplastics, which are then consumed, or through us washing our clothes that might have plastics in them, and the microfibers then make their way into the oceans. If it's the latter, then you have those microplastics being consumed by zooplankton and then on through the food chain, through filter feeders, on up through larger species, eventually perhaps accumulating within large marine animals. And the problem is not just that those plastics, as we've seen again in many images, they might cause, if you're having large pieces of plastics being consumed, they might then in effect cause the species to starve, or the individual animal to starve, but also that even those microplastics provide homes to viruses and bacteria and toxins attached to them, such as heavy metals, and these may leach out into the animal that or fish that consumes them. When they do, they may then cause illness and disease. If the effects of consumption or of being caught in plastics means that we have fewer large marine animals in the environment, then the mixing function that they perform disappears. So by the mixing function, I mean that large marine animals, as they like whales, as they dive to the ocean floor to feed and then come back up to the surface, they bring nutrients back up with them. Those nutrients then help feed and provide the nutrients for the phytoplankton, which in turn absorb carbon dioxide from the atmosphere. So no large animals providing the mixing, then fewer nutrients at the top, so fewer phytoplankton, so less of an effect of the ocean as a carbon sink. So again, the question is, well, what can we do about that? And again, that there are a few sort of options, and that we could say that there are some laws that to some extent address this already. I've mentioned obviously the Climate Change Convention and the Paris Agreement before. We also have some other laws that, in this case, where actually climate change regime being part of a larger system of law is quite beneficial. So you have the Food and Agriculture Organization voluntary guidelines on the marking of fishing gear, which is designed to return lost gear to fishing vessels, so meaning that they have less that they need to purchase in future, but also to hold states to account if they've simply abandoned fishing gear. So the idea is it's taking it out of the oceans. We've got MARPOL, which is a convention applying to shipping, Annex 5 of which bans the disposal of plastic waste, basically overboard. The plastics from shipping is a relatively narrow or minor contributor to plastics in the oceans, and the Food and Agriculture Organization voluntary guidelines are just that. They're voluntary and they're guidelines. They're not obligatory in any way. So they have a limited effect in some sense. We do have a larger or a more important convention in the sense than dealing with plastics in the oceans. So the United Nations Convention on the Law of the Sea, Article 207, addresses plastics from land-based sources. But as we can see, it suffers from the same sort of problems as the climate change conventions. It simply requires states to adopt laws and regulations to prevent, reduce and control pollution of the marine environment from land-based sources. So it doesn't give you a timeline, and it simply says they have to take into account internationally agreed rules and standards. Taking into account doesn't mean necessarily complying with them, because the states, when they're adopting their laws, could take into account other issues as well, such as the impact on the economy or their impact on their society. So we have an issue there, and again, we've got another fairly weak obligation. And when it comes to plastics, we've got a second problem in that paragraph 4 reminds us that states are to endeavour to establish global and regional rules and so on. When it comes to plastics, we don't really have terribly much by way of global and regional rules. We've got some soft law measures, so these are non-binding measures, but an awful lot of these are really aimed at developing guidelines for monitoring and understanding, so trying to work out the scale of the problem and share information on the scale of the problem. So we don't have much within international law at present that helps us protect the oceans and the carbon sink function of the oceans from the harm that's coming from plastics. Potentially we could do more, but it's not there yet. And one of the issues is that, again, this comes back to the point that we have these different regimes operating under international law. Any measures that are likely to be adopted to address plastics in the oceans are more likely to come under the UN Convention on the Law of the Sea. And that means they're less likely to be focused on the issues of climate change and protecting the carbon sink. They'll be more concerned with protection of biodiversity, perhaps protection of fisheries. Now, the interests might overlap, but they may not be the same. They may lead to the emphasis being placed somewhere slightly different. Of course, again, individual states could take measures on their own to try and limit emissions of plastics into the environment, but their measures are going to be quite limited in extent in that they have limited jurisdiction up to about 200 nautical miles when it comes to dealing with something like the emissions of plastics. Beyond that, in international waters, the states have no jurisdiction on their own to take measures. And the second, probably bigger problem for any individual state trying to take measures is, of course, the existence of ocean currents, which carry plastics thousands of miles. And so what any individual state, while individual state might reduce the amount of plastic going into the oceans, they're not necessarily protecting the waters around their state. So, conclusions and way forward. Well, I think the way forward in some ways is quite difficult to see. I think the message that I'm trying to get across through this talk is that relying on law to solve climate change is very, very risky. We have a real challenge in getting agreement on clear and sufficiently demanding laws. There are so many interests at stake from states, and there are so many measures that need to be taken that the time that would be required to have a sufficiently detailed laws developed, I think it would be far too long compared to the time that we have in which to act. The climate crisis is here now, and we know we need to take measures. So going through these relatively slow processes of getting international agreement and relying on that to make a change is really quite risky. Unilateral action by states is possible, but again, its effectiveness is limited by the existence of these other laws, like trade and so on, and by the interconnected nature of our world. So I think then really that, and I know I'm a lawyer saying this, and maybe I'm writing myself out of a job, but I think there are other areas of law where we can perhaps be a bit more effective. But I think when it comes to climate change, we really need to think of other ways to prompt action. And I think this is where individual responsibility, be that of us as private individuals or of industry, I think this is where it's perhaps, if we can start to focus much more on that, then we may have more opportunity for success. And I am very conscious of the fact that we all have different capacities to take action. We all have different capacities to think about the transport that we use, or what products we buy, or where we buy products from. But I think that is a conversation that we as a society need to have. What is our responsibility as individuals, and what is the responsibility of companies? What should they be doing for society? So thank you very much for listening. I'll be happy to answer any questions if there are any. Yeah, thanks again for being here today.
Thank you, Elizabeth. That was really fascinating, even if your conclusion was a little down at the end there. It was really, really interesting and so clear. So thank you. That was brilliant. We do have some questions. We have three really interesting questions so far. So I'll start with Edward Hanna's question. Have we learned anything from laws invoked to tackle the current pandemic and the response of people and organisations that can usefully be applied to the climate crisis?
That's a really interesting question. I mean, yes, we know that it's possible to impose travel bans, for example. We know that it's possible to change the products that industry focuses on. We've seen the ramping up of the production of PPE, and companies moving from producing, for example, fashion items to producing PPE instead. So we know that it's possible to make these rapid changes. But one of the challenges that we're seeing, I think, is certainly when we look at things like the travel ban, is that the relative exhaustion of people for these restrictions. So we need to, there's a balancing act to be taken. We could, I think, work with industry, and we could pass laws to encourage industry to change very quickly to different forms of production or producing different types of goods. But there has to be an alternative for those industries for it to be acceptable. So it can't simply be to say, well, we're no longer producing any ships. All the shipbuilders have got to go off and do something different, produce fashion items instead. That's just not going to work. So it has to be palatable. But the other issue is restrictions on what people can do, restrictions on individual freedom. Even if people didn't travel terribly much prior to the pandemic, the very notion that they can no longer do it is quite challenging. So I think one of the lessons has to be that we need to be mindful of the need for consent of the regulated as much as for change in laws.
Okay, thank you.
The question.
Thanks. Bob Mortimer has asked a non-international question, but questions about how our government might be acting in ways which worsen the climate crisis, and what law has to apply to that.
Well, what law? I mean, we can. In the UK, it's a little bit difficult to take sort of public interest claims against the government. It would be very nice if we had that possibility to be able to then challenge more easily developments like the Heathrow runway. I think there are mechanisms that can be used through the normal, consultation processes, but it is very difficult, or it can be very difficult at times, if a government is absolutely committed to a particular development. There's only so many things that we can do through the legal processes to limit those actions. So I don't know what else I can really say about the attempt to stop it, other than I certainly believe in the right to protest, as long as it's peaceful protest. And I think, again, as individuals, we have an issue or an obligation almost to use that right. If we think something is wrong, we need to be using the normal pressures or methods to write to our MPs, write to the departments that are involved, but also get involved in protest if it seems to be significant and to warrant that sort of action.
Thank you. And then Luke Bideau has asked, with causation clearly established in so many instances, how can countries still not do the right thing or be drawn to it? Are the biggest culprits still entitled to vetoing as they see fit?
Yeah, good question. I guess it comes down to the problem of sovereignty again, in that, as I mentioned at the start, states have to give their consent to be bound by a treaty. And if they don't give that consent, and if they choose not to continue to give that consent, then they can withdraw from the treaty. And there is no mechanism to make law without the consent of states. So that's why vetoing still occurs. And I think that's why I think actually public pressure is terribly important, because it's really public holding their governments to account that does lead, in most instances, to the biggest changes taking place. Why countries still don't do the right thing, I can only hazard a guess that it's because of economic interests, so I think that's what lies behind it. And I think what we can do, and perhaps need to be doing as a society, is thinking again about the role of corporations within society. Is it just about maximizing shareholder profit, which is the current main objective of companies? Or should it be also about providing, or instead about providing benefits for the community, providing employment, providing environmental benefits? So I guess I've answered your question with another question, Luke.
Yes, thank you. Right, so Peter Williams has asked two questions. I'll pick out the second one, because you've touched on the first one already. How do you think individuals can be most effective in combating climate change at an international level?
Well, that's an interesting question. I don't know what individuals can do at an international level, in that I guess where I see the role of individuals is in two things. One, as I've mentioned, in lobbying governments and placing pressure on governments to themselves then negotiate and either to take measures with nationally or to negotiate international agreements. And maybe perhaps that in the same way, being members of relevant NGOs that will help bring that pressure to bear on the governments. But I think the second issue is then, so far as we can within our lives, to think about what products we buy, how we consume, how we travel, where we travel, whether we need to travel. I think this has been one of the really interesting aspects of the pandemic. As academics, we travel quite a lot to give papers in different places. And now suddenly we're doing it all virtually. And it's opened up so many wonderful opportunities to meet with people that we wouldn't otherwise have a chance to meet with, to attend an event in Reading, Glasgow, and New York all in the same day. We've never been able to do that before. So there are some opportunities that arise. And we as individuals can think about how we do things differently as in our own day-to-day lives, and perhaps in our work lives as well.
Yes, absolutely. And Philip Jackson has asked, how optimistic are you for a law of ecocide?
Well, Can I ask what the timescale is? Because I think we might, maybe if the timescale is about 100 years, then yeah, I'm reasonably optimistic. If you're talking 5 years, then I'm not optimistic at all. So perhaps I think in time it might arise as people realize the um, what should I say? I was going to say as people realize the importance of protecting other species, but maybe importance is a suitable enough word. I don't mean that necessarily in that they're important to us, but this idea that we are part of and we are just one individual species within a larger world of species, and we have no business, if you like, in killing off those other species or in killing off ecosystems. And I think that realization may dawn at some point, maybe in my lifetime, maybe not.
So could you just say what ecocide is, because I'm sure not everybody listening.
So ecocide is the idea, in the same way that we have a law prohibiting genocide, which is the killing or persecution of particular populations. Ecocide, again, is the same idea, that we would have a law prohibiting the killing of a species or the extermination of a species, or significantly persecuting it. So in theory, it could apply to something like bees with the use of pesticides or certain pesticides when we know that they are harmful.
Yes, absolutely. And then I think one more question, if you're okay, Elizabeth, you've been great answering so many. But Keith Scarrett, what powers does the ICJ have to penalise a country for ignoring greenhouse gas emissions guidelines or compensating a country that takes unilateral action to reduce emissions to the detriment of its own economy? Very interesting.
It's an interesting question, and the answer is actually quite simple. It has no powers. So the ICJ can only hear a dispute that's brought before it, and that dispute has to be between states primarily. There's some possibilities of a dispute between a state and international organization, but so it would only be if one state was able to demonstrate that the actions of the second state in ignoring the greenhouse gas emissions guidelines had led to harm. So if the UK could demonstrate that the actions of the USA had led to harm in the UK, then the ICJ could decide that the USA was responsible and had to make reparation. Other than that, it just doesn't have any powers at all.
Okay, thank you. Well, thank you, Elizabeth. That was fabulous. And you've got lots of people in the chat thanking you for your presentation. So I think that was fabulous and really helped us all to think about something we haven't, many of us haven't thought much about before. So thank you so much. I'm just going to let everyone know we've got one more talk in this series coming up next week. Professor Ted Fuller and Dr. Claire May will present climate change and the shared futures of business and society. So I hope that many people can join us for that one too. And that will be the last one in this series, but we're definitely going to have another series. There is so many areas we haven't explored yet. So those of you who feel comfortable writing to me, please let me know any ideas for future speakers. But anyway, just remains to thank us once more, thank Elizabeth once more, and to thank you all for being our audience today and asking so many brilliant questions. Thank you, everybody. Bye-bye.
Thank you.